اگر آپ سمجھتے ہیں فیصل وابڈا صاحب نے ریپینٹنٹ ہیں تو ٹھیک ہے چھوڑ دیجئے, اگر آپ کے موڈ میں نہیں ہے تو مت چھوڑیے, اس کو لائف ٹائم بین کر دیں. یہ سوری ٹو سے یہ دس ڈز ناٹ میک فار سسٹینیبل لا. So please, we wanted a larger discretion. اب یہ میں نے بار بار بھی ذکر کیا ہے, یہ جو چیزیں آئی ہیں آئین میں یہ کس راستے سے آئی ہیں؟ کیا لوگوں نے پارلیمنٹ نے بہت سوچ سمجھ کے یہ قانون سازی کی؟ نہیں, ان پہ تھوپی گئی یہ چیزیں. آپ بات ہی نہیں سن رہے نا. 18th امینڈمنٹ سے پہلے آیا 62(1)(f). انہوں نے یہ 62(1)(f) تو انہوں نے ڈالا ہے, کسی میں 62(1)(f) کو صرف انہیں وہ ٹیوننگ کی اس کی. یار اب آپ سن لیجئے نا پلیز. تو یہ جبرن جو چیزیں ہوتی ہیں نا, میری مرضی والی بات, ایک شخص کی مرضی پورے پاکستان پہ حاوی ہو گئی. انہوں نے فیٹ اکمپلی دے دی, کر لو یا میں بیٹھا رہوں گا 25 سال اور. انہوں نے کہا اچھا آپ جائیے, ہم کر دیتے ہیں یہ 8th امینڈمنٹ کو اور 18th امینڈمنٹ کو. پھر وہ آپ کا اسٹریٹ پروٹیسٹ, خطرہ, یہ وہ وغیرہ آپ نے دیکھ لیا, تباہی جو پاکستان میں ہو چکی. کوئی بھی ریپینٹنٹ نہیں ہے اور وہ لوگ پھر الیکشن لڑ رہے ہیں. ریپینٹنس ہوئی کوئی؟ انہوں نے معافی مانگی کسی سے؟ پورے پاکستان کو وہ بنا لیا, ہوسٹیج بنا لیا. ٹھیک ہے, بنا لو پاکستان کو ہوسٹیج, آپ کی مرضی ہے. اور ہم ان چیزوں پہ کھیل رہے ہیں ایک تشریح پہ. اب براڈر پکچر بھی تو لگائے نا سامنے. یہ چیزیں ساری آئی ہیں مارشل لاء ڈکٹیٹرز کے دوران, آپ کوئی ذکر ہی نہیں کرتے ان چیزوں کا. I don't know, we are sitting in a constitutional court, we talk about the rule of law, مگر وکیل سے کے منہ سے ڈکٹیٹرشپ کے خلاف بات نہیں آئے گی. یہ کیا ہو رہا ہے؟
میں نے تو نہ ڈکٹیٹرشپ کے حق میں کی ہے نہ خلاف کی ہے. پلیز الاؤ می ٹو سے.
نہیں کر رہے خلاف.
میں جتنا ڈکٹیٹرز کو میں 18th امینڈمنٹ والوں کو اتنا ہی کرٹیسائز کرتا ہوں.
دیکھیں وہ تو آسان ہے نا, وہ سارے پارلیمنٹیرین ان کو کرٹیسائز کرتے ہیں.
کیوں آسان ہے؟
مگر آئینی بات کیجئے.
میں سر جو بندوق لے کے بیٹھے ہیں اس کے ساتھ تو نہیں لڑ سکتا نا. جس کو میں نے ووٹ دیا میں اس کو اکاؤنٹیبل کروں گا. انہوں نے کیوں نہیں یہ ایشو ریزالو کیا؟ انہوں نے کیوں نہیں 62
your right to argue, to have an opinion, and we respect your opinion. Please carry on.
Let's conclude.
I am not saying کہ یہ ایک شخص کی ڈسکریشن ہے. میں اسی لیے کہہ رہا ہوں کہ جی وہ ایک سوٹ کے تھرو یہ ہو, آپ اس سجیشن کو مانے نہ مانے آپ کی سوال.
ٹھیک ہے, آپ بڑھیں نا آگے.
وہ سوٹ ہوگا, اس میں ایویڈنس ہوگی.
ٹچ نہیں کر رہے ہیں, یہ میں صرف کہہ رہا
سر. میں اسی پہ آ رہا ہوں. میں تو ابھی میرے آرگیومنٹ کے 2 فلیگز تھے. ایک تو یہ کہ جی سمیع اللہ بلوچ کے اندر سے یہ رستہ نکلتا ہے. آپ سمجھتے ہیں نہیں؟
مسٹر زہر, آپ سے یہ بھی نہیں لینا چاہ رہے ہیں. We were in amicus and we were throwing this question that for a minute, if we imagine there is no Sami'ullah Baloch and the constitution is in front of you, how would you like to read 62(1)(f) as an unlimited provision or with some time frame in the totality of the constitutional scheme?
میں exactly اسی پہ آنے لگا تھا. میں یہ کہہ رہا ہوں کہ وہ اگر میں اپنے طریقے سے چلتا تو چیزیں 2 پرانگز ہیں میرے آرگیومنٹ کے. ایک تو یہ کہ جی آپ کو سمیع اللہ بلوچ کے اندر سے رستہ ملتا ہے, وہ میں نے عرض کر دی. وہ سوٹ اگر ہوتا ہے اس میں ایویڈنس ہوتی ہے, گڈ کیریکٹر بیڈ کیریکٹر اسٹیبلش ہو جائے گا. کسی کی ومز اور ڈسکریشن کی بات نہیں ہے, جوڈیشل ڈٹرمنیشن. The second prong is if your lordship either decide to overrule Sami'ullah Baloch or, as your lordship said, your lordships are writing on a clean slate. What would you do? Now, my lord, the principle there, one principle which I think is directly relevant, is that where the constitution provides a certain manner of doing certain things, and in a similar situation it does not provide the manner as to how to do something, then the guidance provided in the first situation can be used for the second.
So you're saying guidance from 63 could be taken to look at 62?
But there is an issue with that, my lord. Now, and there are 2 cases that I cite. My lord, the first is the famous judges case, Al Jihad Trust versus Federation of Pakistan, PLD 1996, Supreme Court 324 at 531. Now, in this case, the issue was what is the time period within which judges should be appointed, and the Constitution is silent on it. So what this Honorable Court did was that they said we will take guidance from the time period given for the appointment of another constitutional office holder, the president, which is Article 41(5), and use that time period for the purpose of appointment of judges also. The same reasoning, my lord, was employed in a full bench case of the Lahore High Court in a judgment authored by Justice Mansoor Ali Shah.
Why are you after me today?
जी
Why are you after me today?
मैं तो आपके अपने दे रहा हूँ और फिर भी हमसे ये गिला है कि वफादार
That's
नहीं.
a lighter note. Just to ease things a little, you see. अच्छा बताएं.
मतलब रब नवाज धदवाना वर्सेस मोहम्मद अकरम, PLD 2014, Lahore 591 at 622. Now here again the question was that there was no period given for the appointment of the Advocate General, and your lordships used the same principle, though Al-Jihad Trust wasn't cited, but the same principle was used. The 30-day period given in Article 45(1) was used, and a 30-day period was prescribed.
So your argument is that if in the Constitution there is a bit of a void and there's no clarity regarding time frames, then wherever there are similar provisions of time frames, that could be imported or read with those,
It can be.
and to harmonize the scheme of the
Yes.
Constitution.
If your lordships were to overrule Samiullah Baloch, or if your lordships were writing on a clean slate, there was no, then this could be done. But there is the problem with that is that the Constitution in somewhat similar situations provides multiple guidelines. 63(1)(h)
Yeah, the
says
three,
5 years, but then there is also provision for 3 years, 2 years.
Right.
So your lordships will have to see which is the closest.
one has to probably rely on one time frame.
But if, and I'll just sort of conclude.
One question, fundamental right. The one fundamental right which I think would be involved would be Article 17.
My lord is finished.
If there are two interpretations of Article 17,
My lord.
will that, the one favorable to the subject be preferred, or an interpretation which is coming in another part of the Constitution, which is 62 and 63, which I assume has a lower status than the fundamental right chapter, would prevail?
My lord, the fundamental rights will be given, provisions regarding
If
fundamental
there are
rights.
two in conflict, which will prevail?
My lord, the one giving the fundamental right, there is no issue with that.
Article 17
Yes.
enables elections.
Yes.
And the only disqualification specified, mentioned therein is against Pakistan and all that.
My lord.
ठीक है? So constitutional framers were very much aware. So when 62(1)(f) was inserted in the Constitution, another amendment was not brought in to water down Article 17.
Agreed, my lord.
17 was left as is. So if we have to reconcile the two provisions, rather than going this way, we can simply say a right of this right is paramountcy because of Article 17, and there's no specific mention in the Constitution. And like my lord said, if there was no Samiullah Baloch, how would you interpret it? We wanted to hear that view.
That's the question I want.
So one more question. I mean, now that you've read Samiullah with that kind of a Rhodes Scholar eye, I just want to know that does it talk about Article 17,
Samiullah Baloch discusses this in detail.
the strength of 17,
Yes.
and then looking at the
Yes,
Constitution?
yes. And there was, all council had invoked the principle of.
No, the submissions are there, but is there a discussion
Yes,
on
yes.
17?
Yes,
So
they-
what do they deal with? How do they deal with it?
Well, they said, well, this is not excessive. They said this is not an excessive. This last, your lordship may note, this is in the last 4 lines of para 35. Therefore, the permanent incapacity of a candidate for election under Article 62(1)(f) of the Constitution is not an arbitrary, excessive, or unreasonable curtailment of a fundamental right under
So
Article
they take care of
72.
that? And do they do a comparison on the thing that we just talked about, that there is a time frame in 63 but not there in 62?
Yes, yes, yes.
What do they say to that?
My lord, they did not accept that. They said that these are separate.
Separate provisions.
These are separate. Your lordships may just note the page numbers.
Yes?
There is extensive discussion on that. If your lordship.
So the discussion comes to an end by saying that these are two separate distinct provisions, and
yes,
that's why
my
we
lord,
cannot overlap one.
The discussion starts at para 27
Right.
at page 438
Fair enough. ठीक.
and it continues till page 442.
ठीक.
And your opinion on it?
Sorry.
Whether they are the same, are they interlinked?
For this purpose, I mean, the Siamese twin argument, are they twins here or are they separated?
Here, I think they are separate. They are separate.
So then this argument of Samiullah is correct in your view, that we cannot import the concept of timelines in 63 into 62.
Yes, my lord.
Even though earlier you said that one way of interpreting the Constitution holistically is to pick up a time frame from one, and you refer to two judgments also,
Yes.
and important to the other, but now what's your position?
No, my lord, I'm saying that in my view, the balance that Samiullah Baloch has drawn is correct. If your lordship, sitting in a larger bench, think that that balance is not correct and should be
No, we
done
want
away
your
with,
opinion on it.
my preferred view is that Samiullah Baloch, the balance
Not
is
Samuel
right.
Baloch, the fact that can we pick up a timeline from 63 and important to and
My lord,
62?
only if your lordships do away with Samiullah Baloch.
नहीं माय लॉर्ड ने कहा ना कि इमेजिन के नहीं है वो
नहीं है तो मैं-
नहीं है तो फिर आप कर
आपकी
सकते हैं।
राय
नहीं, फिर अगर कर सकते हैं तो
माइकल को हम तरजीह दे रहे हैं हम आपकी राय सुनना चाह रहे हैं
आप दो चीजें कह रहे हैं ना, आप कह रहे हैं कि you agree, and we talk about what Mr. Uzair Bandhari has to say,
I know.
that 62, 63 are two distinct provisions, or are they interchangeable? Number one, for the purposes which are under discussion, and second, whether at all, if there's a void, no time frame, and there's uncertainty attached to 62, could we bring in that certainty from 63 and put it in 62? What's your opinion on this?
My lord, my own take, if I was writing the judgment, would have been, I would have done the same thing that your lordships did when in terms of Article 175A, send it back to the Parliament for them to sort this issue out.
Parliament has
Because-
enacted the law now. 5 years has been fixed for
My lord, that law for me goes against what Samiullah Baloch has held. That
No, suppose Samiullah
law is ultra vires.
suppose Samiullah is not there,
My lord.
and the Parliament clarifies through the enactment. Can Parliament do so?
Well, Parliament, for the purposes of Article 62, under Article 62, the Parliament has no power to legislate. It is there in 63(1)(p). Then Parliament can legislate there.
62(1)(f) says subject to law.
Well, but
And if
for the
law,
purposes of
the
disqualifications.
Mr. Uzair, on this ground, I mean, maybe you want to sort of comment on this, that one view of looking at it is that the declaration that's coming, from wherever it's coming from a law, some violation of some law. So therefore, if you want to correct that, and that's an unlimited declaration, which is arising out of a law, not out of the Constitution, then the law has put a time frame on that declaration. So why can't that be read into that declaration? So every time we read the declaration of court of law into 62(1)(f) would be a declaration which is time bound,
My lord, but
because it's not tampering
no,
with the
my lord,
Constitution.
that is not how how clause F is worded. It does not say the declaration is flowing from any law. The
It is saying
declaration,
from a court of law.
my lord, the court of law, not declaration under any law.
No. I'm saying that whatever that declaration is, be it from the constitutional court or be it from the plenary jurisdiction, that declaration itself is arising out of some violation of a law. Please appreciate my
lord.
I'm saying it doesn't matter what court it is, the declaration is arising out of some violation of some law, not the Constitution. Either it's the Election Act, either it's the University Act, it's whatever you call it. So then the law now says that any declaration for the purpose of 62(1)(f), when it's used, because it's arising out of a law, would have a period of 5 years. That's what I'm trying to say. There's a bit of a distinction.
But, my lord,
Had there been a violation, I understand, had there been a violation of the Constitution itself.
Bandhari, at least empathize with us.
My lord, my lord,
The kind of things we have to deal with.
my lord, your lordships have not only my full sympathy, but
आज के बाद ये 5 साल के लिए डिस्क्वालिफिकेशन होगी, लेकिन सब्जेक्ट टू डिसीजन बाय अ कोर्ट ऑफ लॉ.
सर मैं कह रहा हूँ वो इसीलिए तो जो जस्टिस याहिया का सवाल था सर, ये उसके लिए भी रेलेवेंट है. क्वालिफिकेशन और डिस्क्वालिफिकेशन को कॉन्स्टिट्यूशन ने दो सेपरेट कॉन्सेप्ट्स के तौर पे लिया है. डिस्क्वालिफिकेशन पे उन्होंने पार्लियामेंट को लॉ मेकिंग पावर दी है. क्वालिफिकेशंस के बारे में आर्टिकल 62 में 63(1)(p) का कोई इक्विवेलेंट नहीं
आपने
है. तो मेरी सबमिशन ये
बड़ा
है.
आसान कर दिया आपने. फैसल ऑर्डर का केस लेते हुए कोई भी आ जाए सुप्रीम कोर्ट के सामने,